is a letter from Attorney Gorham regarding William Felkner, and just want to frame some discussion. I just want to make sure that we all listen respectfully and we discuss respectfully, and we all conduct ourselves in the most professional manner possible. There's been some sensitivity around this issue, and I just want to remind everybody that we're role models and we're here to do school business, and let's hope that we act like adults and not make any snap judgments. Okay.
Thank you, Madam Chair. Shall I address from the podium?
I appreciate that. Thank you.
Good evening. My name is Nicholas Gorham. I live in Greene, Rhode Island, and I work in Situate, Rhode Island as an attorney. I'm with the firm of Gorham & Gorham, and with me here tonight is one of my law partners, Chris Anderson, also from Coventry Green, same thing. Madam Chair, thank you for that introduction. I couldn't agree more that the best way to have this discussion is in a civilized manner, and I made a point of putting that in my letter, that I hoped we could have a civilized discussion, because it could very well be that we agree on far more than we disagree on, and that we can get this issue resolved without perhaps any interruption in the representation of the people of Hopkinton. Although I am here to represent Mr. Felkner, to be quite straightforward and frank, I do see the issue before you that was framed by your esteemed counsel, Mr. Anderson, is, really quite simple. Can Mr. Felkner serve as a member of the Hopkinton Town Council, a separate body politic from the Chariho Regional School District, and also serve as a member of this esteemed committee? Can he do it? And the only thing that I'm really here for tonight is what we're going to do in the interim, because the question's going to be resolved one way or another. It's absolutely going to be resolved, because Mr. Felkner really has no choice but to press this. He was elected by the people, and I know what it's like to be elected by a group of people to represent them. And that's exactly what I think Mr. Felkner feels it's his duty to do. He was elected to the town council, and he was elected to the school committee. And he has the duty to represent the people who elected him, who happen to be the exact same group of people. So he has to press this. He has no choice, really, when you think about it. Just like you have no choice. It's not like after you're elected, you're not going to show up for meetings and just never show up. You were elected to do it, to show up, to do your job, and I know that's what you're doing. And I know that's what you thought you were doing when you took a vote a couple meetings ago pertaining to Mr. Felkner. But let's just think about what we could do as an alternative during the time that this question is resolved. This question is going to be resolved by the courts. That's the proper place to resolve this question, is the courts. It's not, in my view, it's not to be resolved by a school committee. You shouldn't have to answer questions about what the common law is, about incompatibility. I don't think you even have the authority to do that under your charter or under Rhode Island law. I think that's a question that the courts are supposed to wrestle with, and it's not an easy question. The only thing we're here for tonight is what are we going to do in the interim? And to me, the fairest thing to do is to let Mr. Felkner serve until a court says he cannot. And you know something? You have the absolute power tonight to reverse your decision, which in effect resulted in the disenfranchisement of a group of people who are part of your body politic, the Chariho Regional School District. You have the right to do that tonight. You can do that. You have the power to just change it and say, you know something? we made a small mistake at the last meeting. We shouldn't have said, you can't serve until you get a court to say you can. What we should have said is, there's a question, let's see if Mr. Felkner is willing to have it resolved cooperatively, collaboratively with us as a group to get an answer. But we'll let him serve until we get that answer. That was the right way to do it. You can still do that. You can do it tonight. You can do it in one vote. And as I said, it's inevitable that we're going to get this issue resolved. It's really just a matter of whether or not Mr. Felkner is going to be allowed to serve. Now, Mr. Anderson came fully prepared, Chris came fully prepared to answer any questions you have about this question of incompatibility, questions that maybe, your solicitor has addressed, but we have a view. We have a view about why we believe Mr. Felkner can serve. We believe we're going to be successful in persuading the courts, whether it's the Superior Court or the Supreme Court. We believe we're going to be successful in persuading them that he actually can do both. And if that happens, then we know that we've really disenfranchised the people of Hopkinton. Because then we'll know he should have been allowed all that time. And when you weigh, the harm that's going to be occasioned by that against the harm of letting him serve in the interim, and there is no harm. There is no harm in letting him serve in the interim. None. And I would implore anyone to point out the harm that could be occasioned in letting him serve in the interim. I don't think there is any. But when you weigh those two, I think you inevitably come out on the side of letting him serve. And that's all we're here to ask you to do. Change the decision. Not change your decision to get an answer, but just change your decision about whether the people of Hopkinton are going to have representation in the interim through Mr. Felkner, the person they elected. They elected him. And as I said, Chris is here. Any questions at all that you want to ask? We're fully prepared to go and explain any questions you may have. You might want to get a different viewpoint on the common law of incompatibility. We're ready to address any questions you have. I don't think this is the right place to do it, but we came prepared to talk about it. But mostly I just want to say, think about it. I mean, the hardest thing to do in a legislative body is to admit you made a mistake and change it. But sometimes it's really the best thing to do. And tonight, I really truly believe that is the best thing you can do. Just change one part of your decision, which is let him serve. And I'd be happy, again, to take any questions you have. Any. With the chair's indulgence, that is. Madam Chair, I didn't mean to...
Thank you, Mr. Abbott.
Yes, Mr.
This
Abbott.
law of incompatibility, does that go back to like English common law and like Henry VIII?
I think it might go further than that. It may go to medieval
The Magna
times.
Carta?
Excuse me?
The Magna Carta?
It could.
Yeah.
I didn't go back that far. I readily confess I did not go back to the Magna Carta. But it could. The question here, though, Mr. Abbott, I don't think we're questioning whether the doctrine of incompatibility exists. As lawyers, it's always the application that's most difficult. That's why we have courts. It's the application that people disagree on. We don't disagree that there are laws that have to be followed. What we disagree on is when and how they should be applied. And I think that's the heart of the disagreement here. Not that there's a doctrine, but how it should be applied here, if at all.
Mr. Pulaski, would you mind opening that question?
You might not want to answer this question. It might not even be a proper question. I'm aware of it as I ask it. Knowing you and knowing your father and knowing all the years two of you spent in the legislature and both houses, if I'm not mistaken, have you ever known anyone to serve as on the house